Okay, we'll quickly go through within this 1.5 hour about what have you learned. Okay, adversarial system, please remember to choose your side. Okay, and Evidence Act itself is actually drafted by this guy, Sir James Stephen, and it governs how the evidence goes into the court. As simple as that. This is a procedural law. This is nothing to do with the substantive law. Okay, and the purpose of evidence law is to regulate how the facts is being proved in the court, ensure procedural justice, okay, and save the court time so that we will not be stuck on the issues of how this evidence should go in, should not go in, something like that, okay? And best evidence rule, etc. This is the purpose of the Evidence Act 1950. You must know you must know that Evidence Act itself is a codified statute. So when a law is being codified in Malaysia, so common law can only be referred when there is a clear lacuna or vacuum in law. Okay, very important. And you must know that by now, Evidence Act is not applicable to affidavit, inquest, and also arbitration. Very important. It is only in the judicial proceeding it apply. Okay? And part one is about relevancy. Relevancy also very important, I think very important topic. You'll be tested on circumstantial evidence. Like, for example, you'll be given a scenario, so and so is happening there, get murder or get there is a theft issue or even a civil case. So they'll ask you each and every single piece of evidence is suitable to go in by which section. Okay? And you must start your answer by a general statement which you have to use section 5. This is how you tackle relevancy question. You must tell the examiner that only two things can be admitted in the court proceeding. Number one, if it is a facts in issue, or number two, if it is not facts in issue, then it is relevant facts. Relevant facts means fakta yang berkaitan. Okay? And what is facts in issue is that very simple, to make it very simple, facts in issue is the element of the case itself. Okay, if you have a civil case, take for example, you have a negligence, then the facts in issue will be whether the defendant owe a duty of care to the plaintiff. Is that particular duty being breached because the defendant had acted in a way below the standard of care? And then subsequently, there will be causation. The causal link is the fact in issue and also the related damage in this question. So this is facts in issue. Other than that, we can also, for example, the negligence, you can also tender relevant facts, which is not directly occur, but it can support your claim. A very good example would be some sort of medical bills in negligence case to prove the extent of injury. As a matter of fact, okay, if you show all these bills, okay, it will show damages, isn't it? Wait, okay. And if let's say, for example, Remember the last year punya issue? It's like if you tender the gate, the gate itself, the height itself is not high, then you can show the opportunity of the dog escape. So this will fall under your relevant facts, section 7, for example. So this is how you play along the game. And on top of that, you have to also mention section 136. 136 is court has the discretion whether they the relevant facts itself you can tender as a plaintiff or a defendant, but somehow or other this is the decision of the judge whether to allow the admission of such evidence or not. So this is the discretionary power that ought to be exercised by the judge. And you can use the case of Datuk Sri Anwar Ibrahim, famous judgment by Augustine Paul. Okay, so this is how you play around. And so this is what we call section 5. Must put section 5, please. Only facts in issue and relevant facts could be admitted. And the whole chapter from section 5 to section 55 are all related to relevant facts. And when you talk about relevant facts, this is all of them are not direct evidence. They are circumstantial evidence. Okay, circumstantial evidence are very important to understand this. I give you one example. Here, this is my wife and this is me, and I kill my wife. Okay, the direct evidence, the facts is in issue is that I have the act of killing plus the intention to kill. And take for example, I'm now in a hotel. There is a CCTV capture the act of killing. Then this CCTV itself is direct evidence. It could amount to establish the facts in issue that I stick a knife into my wife's body lah. Okay, this is direct evidence. But whereas things like blood-stained knife or subsequently CCTV in the lift showing that I was very panicked and run away, all that is circumstantial evidence. Let alone if I bought a very high sum of insurance policy, that will form the motive of killing. So this is how it plays around. Okay. So okay, when you have a piece of evidence, number one, decide on the relevancy issue, section 5. Okay, that is two, facts in issue, and also relevant facts only can be allowed to be admitted. And then second issue, it comes to the admissibility. That is your section 136. Okay. Both these are so-called question of law. Okay, question of law means you can only tackle it with the provision of evidence act in order to decide whether these evidence are suitable or not. But at the end of the day, the judge will need to also give weight to that particular piece of evidence. I give you one example here. Same thing. It's the murder of my wife. Okay. I bought insurance policy. Okay. Put under me as the nominee lah. Okay. I'm the nominee. I will get the money if she died. Okay. But so this is relevant as a section 8 motive to kill. And then, since this is relevant, the court will exercise its discretion under Section 136 to admit this piece of evidence. Subsequently, the weight itself is subject to the fact. Let's say I tell you the insurance policy is only 500 ringgit. Yes, even though there is some gain, but as compared to a 5 million ringgit policy, the weight to this, the factual scenario like this will be lower. Now you get me? So this is RAW, the process, how the evidence is being given a judicial appreciation. Okay. And there are a few modes of proof. Okay, this one also you must understand by now lah. Okay, first is there are some witness, saksi, come to court and give oral testimony. So this is direct, they give direct testimony, oral evidence in the court, section 60. Otherwise, they tender documentary evidence. Documentary evidence could be the normal paper type of documentary evidence, or it could be digital evidence. Those section 90A, computer printout punya evidence. In the case where it is warranted, sometimes real evidence will be tendered. For example, the knife, the gun, or in the case of counterfeit, there will the counterfeit, the what we call the currency, they will bring in printer as well as the what we call the evidence. So this is deemed as real evidence. Okay. The best evidence rule is that audit, you don't have to know. Okay. Just now, I brought to your attention relevancy, admissibility, plus weight, and also mode of evidence. That means to say how we present those or tender those evidence during the trial. Okay. Take, for example, if we tender a photocopy document without showing the original. Take, for example, this is a form of agreement, agreement, and this is a civil case. Okay, plaintiff is suing the defendant for breach of contract. So this agreement is just a photostat one. It's a secondary document. The original one did not being tendered because I think the lawyer has some sort of negligence. But as the feature of adversarial system suggests, if you do not object, take for example, the plaintiff lawyer took this evidence and tender it during the process, it is being marked as exhibit. And as the defendant lawyer, you did not stand up and say, okay, I object to this mode of admission. So it amount to cancellation of your right. That means to say you allow this secondary document to be emitted automatically. Okay, so this is how, and the court will ignore whatever your subsequent afterthought submission say that by right this is not admissible. So failure to object the mode of proof is fatal to the person that did not raise objection. Okay, so this is how, but whereas if let's say this piece of evidence is not relevant in the first place. Take, for example, back to the story of breach of contract. Okay, instead of emitting this the agreement, which to prove the existence of a contract between the parties, you're going to emit one news article about the defendant or the plaintiff reputation. So this is absolutely not related to the course of action of the case itself. So even though the what we call the defendant in the trial did not stand up and object, the court will also exercise its discretion under section 136 to reject this piece of irrelevant evidence. Okay, now you get me, Okay. So case law, Noliana Sulaiman. Another one I think is Tan Kok An case. Yes. Okay. Failure to object admissibility. So you try to understand from the point of view RAW. Then you try to argue it accordingly. Okay. Now we turn to the next subject. That is the burden and standard of proof. The burden is inside the provision section 101 until 106, whereas standard of proof evidence act dalam tak ada, so you refer to common law position. Okay, the backbone of this standard of proof and also burden of proof is that you first you have to identify, is it a criminal case or is it a civil case first? If it is a criminal case, DPP or the prosecution will bear the legal burden of proof to convict the accused throughout the whole case. You get me, Okay. In civil case, the plaintiff will need to establish or discharge their legal burden of proof, okay, and on balance of probability. Take for example, more than 51%, more probable than not. Then the legal burden from the plaintiff is discharged. Then the defendant will need to come in and rebut their cases. Okay. A general principle is like this. Okay, first, how you want to talk about legal burden, all that first, is that you must start with section 3. Before you go into the further discussion, tell what is the meaning of proof. Okay, the interpretation clause pursuant to section 3 Evidence Act clearly said that proof, okay, means legal burden or proof. Okay, not evidential burden. Okay, not evidential burden. So you use also R against Jaya Sina to start the case. Okay, subsequently, you have to tally with the facts. Straight away, say the name of the party. Take, for example, if the facts give you Ali is a plaintiff, you must say Ali should have discharged his legal burden of proof. Since this case is about defamation, he must prove that he made a defamatory statement. This statement had lowered the reputation of the what we call the plaintiff lah, among the right-thinking members of the society, then etc. etc. So prove the elements of the case. Must say like that. Since he exert this fact according to section 101, he must tender in order to discharge his legal burden. Okay. General statement is that he who exert must prove. That means to say in a very layman term, who say this statement in the court will need to bear legal burden to prove the existence of the fact. It's not just speaking from the bar. Okay, bukan cakap kosong. Semua benda kita kena ada bukti. So how do you discharge this what we call the burden is you must give some form of evidence. Okay, and in order to impress the examiner, you must roughly know what to give. For example, if you have a case that is about a criminal case, the DPP will need to satisfy the legal burden of proof, isn't it? So he must show something like CCTV to show the theft or robbery took place, and the identity parade, the result showing the face of the what we call the accused has been identified by the victim, etc. So this is how it goes. Okay. So 101, 102. Then subsequently 103. Okay. Just now I said to you, those who exert must prove, isn't it? So this is fall under 101 plus 102. Often than not, these two sections are read together. Read together. Okay. This is legal burden. Impose the duty on the parties that exert the facts must prove. And this is what happened if they fail to do so. If they fail to do so, then the court will not believe what the party was said. So in reference to section 103, this is about the burden of proof of a particular fact. The famous one is alibi. Alibi means here, alibi is only happens in criminal case. Basically, the accused say, I am not at the scene of the crime and somebody can witness my presence. Okay, take for example, I'm now in Bangkok and my wife was killed in Kuala Lumpur. I need to find someone that is in Bangkok to disprove the fact that I killed my wife, right? So I'm raising the defense of alibi here. In order for me to raise the defense of alibi, you have to comply with section 103. This is number one. And you must also put in section 402A, notice of alibi. This is CPC, notice of alibi to PP. Because alibi is a very strong defense. If I'm not there at the crime scene, I could cast a very good doubt to the DPP case that I'm not the killer. Okay, so that's why you have to talk about this section 103 plus section 402A CPC when you raise the issue of alibi. And you can use case like Pamanaban Narayanan, this is Sosila Wati case, Azila Hadri case, that is the Mongolian girl got killed case. Okay, so this is section 104. Okay, whenever you talk about those hearsay exception, take for example, you want to talk about section 32 of Evidence Act. Okay, like dying declaration, the documents which is uh during the ordinary course of business. So to fulfill those, the maker is unavailable, the maker is dead. This sort of preconditions to admit the evidence under this, you bear, okay? Because you are not calling the witness. So this is section 104. Okay, the precondition must be proved in order to satisfy the criteria to admit all these section 32, section 73A Evidence Act punya document, take for example. And section 105 is special defense. Special defense like insanity. I killed my wife because at that time of incident, I was mentally unsound. So this mentally unsound is not the duty of DPP to prove it. It is for the accused to discharge it. How they discharge? Give psychiatrist report. Okay, this is one good example. So you must, like I said, when you answer the legal burden, all this, you have to relate to the fact. Don't just tell the law and salim bulat bulat. It will not help you. Okay, you have to tally with the factual scenario. And mark against PP, very important case in which it is a little bit like the DPP against Wilmington case. Mm. But basically, it said that DPP bear legal burden of proof to prove a case beyond reasonable doubt. Okay, how to say this is beyond reasonable doubt? It has a few scenario. Okay, this is in the judge perspective lah. If the judge believed what the accused said, acquittal. That means to say the accused is released without guilty. But let's say, if the judge do not believe what the accused said, but the prosecution did not actually fulfill or discharge its legal burden, the accused still entitled for acquittal. Okay, so this is how it play. Two things only. So mark against PP. And so standard of proof, whenever you have a civil case, this is on balance of probability. And when you have a criminal case, and this is on beyond reasonable doubt. Okay. So fraud position, in fact, every single civil litigation now is on what we call on balance of probabilities basis, even if it is fraud case. So um, sometimes it's very difficult to identify fraud or forgery. Okay, because forgery often associated with the intention to cheat the parties, right? So you use the case of Sinaya and Sons against Damai Setia. And this case law since 2015, it has a prospective ruling effect. That means any cases after this year should be based on one single standard of proof, that is on balance of probability. That means to say all civil case in Malaysia nowadays is all on balance of probability. Okay. So legal burden, we have said, please, please, relate to fact. Don't tell about the law. Just relate to facts. Okay. Second, we go to circumstantial evidence. Okay. Circumstantial evidence, remember what I said? These are all relevant facts only. Those are not facts in issue, but fakta yang berkaitan. So this is uh, this one. This is admissible one. Okay, admissible. Okay. In some cases, take for example, criminal case. Criminal case, because crimes is committed when there is no body, right? I mean, this is a private doing. Nobody will do crimes in a public or openly. So criminal case often very difficult to have a direct eyewitness or some sort of direct evidence. And in order for us to to prove the case, often enough than not, the DPP will need to gather a lot of relevant facts. And those relevant facts collectively will form an unbroken chain of evidence. And that unbroken chain of evidence must satisfy irresistible conclusion test. That means to say, in my case, okay, I kill my wife. It is only me that is the most likely. It cannot be other people lah, that kill my wife. So this is how it goes with irresistible conclusion test. And this has something to do with the chain of evidence with collection of all these relevant facts. Okay, that means to say bloodstained knife, my CCTV showing me running away, etc. And my DNA was found on the knife, all that. It must not be broken. Okay, so when there's a few cases here, remember Sunny Ang. And one more thing I want you to remember, you have to cite the statute, the provision of the Evidence Act. Not many case law are needed for the examination purpose because, like I've told you, Evidence Act is codified already. You just have to bring in your presentation by one or two cases. Okay, you don't have to tell so much cases. And for you to use those Sunny Ang or Azila Hadri case, all that, you don't have to mention about what happened inside this case. We are not, the examiners are not so interested, but they want you to apply the law well. So this is their objective, huh? Okay. And prima facie case, I think you can refer to section 173F for the subordinate called the summary trial. So this is the definition, and also section 180 CPC. Okay, so this is the definition. Basically, what prima facie is that in criminal case, PP will start the case, right? They'll call saksi pertama, uh, saksi kedua, saksi ketiga, and then subsequently end with the IO lah, most of the time. And through every single witnesses, they will give evidence, like documentary evidence, real evidence, all this will go in. Take, for example, a drug trafficking case, they'll give photos, they'll give chemist report through all the saksi that they have called chemist report, and they'll give the real drugs found in the premise. Okay. After this stage, the judge will have one deliberation. He will have to decide after listening the submission by PP and also the defense counsel. We submit on the points. He has to decide on whether prima facie case has been made out on accused. And this process itself, he must subject to maximal evaluation of all this evidence. He must ask himself one question. If, let's say, for example, the accused, okay, here, if let's say I made this decision, prima facie case was made out against the accused, if the accused opt not to answer any question, choose to remain silent, because the accused got three choices, if he's been called to enter defense. First is that he didn't want to say a thing, remain silent. Second, he can give an unsworn evidence. That means to say tak angkat sumpah tetapi memberi keterangan. This one, the prosecution cannot cross-examine him. And the third one is that he can give sworn statement. Let's say, let's say in this hypothesis, the accused remains silent. Okay, remain silent. Is the judge ready with all this evidence to charge the accused and to convict him? Okay, so this is how it goes, prima facie case. If it is being made out, so this maximum evaluation has done and the judge is happy. If the accused remains silent, means conviction. Okay, the whole meaning is like that. Okay, case law, law chai plus balachandran. No need to tell so much thing. You have to understand and regurgitate what is it to the examiner. Okay. So facts in issue, how do you define it? Sometimes they ask you, okay, facts in issue, you don't have to really memorize all this lah. Actually, quite simple. In civil case, for plaintiff, all these facts in issue means how he want to prove his cause of action in order for him to win. Take, for example, in negligence case, he has to prove that 4 elements law. And for defense, facts in issue means how he want to raise those defense in order not for him to lose. So this is civil. And in criminal, what facts in issue means for PP, how you want to establish whatever mentioned in the charge. Take, for example, rape. Okay. How he want to prove all these elements of the charge is fulfilled in order to convict the accused. And facts in issue in accused means how to raise the defense. For example, okay, so this is what it meant. And relevant fact means it is not a direct facts in issue, but somehow or rather it is associated, berkaitan with the facts in issue. Okay. Again, I give you one example. Rape. Okay. Rape is called unconsensuous penetration into the sexual organ of a victim, isn't it? If you find a tissue paper containing some sperm or semen from the man, so this is relevant fact. This is not regarding to penetration itself, but it is related to the facts in issue. It means ejaculation happens and there is some trace of semen. Okay, so this is how it goes. And take for example, if the rapist spent a night with the victim, this is not important, isn't it? Because this is not direct what? This is not talking about penetration what? So, but it provide like a scenario, like an opportunity for those the accused to commit the rape. Okay. So far, can you follow me? I forgot to ask lah.
Can, sir. But I got a question, sir, in the chat box. I got put my question there.
Later I explain to you if I
Okay.
can. Okay.
Okay.
Can
Thank you.
follow me so far? Am I going too fast? Okay, clear. Okay. So try to use your own language, Actually, I don't know about you, but my English is not so good, but you have to draft your version of answer based on your understanding about the law. Okay? Section 6 is one. Okay, when you are given, normally they test you on the scenario lah. Okay, so this question, section 6, 7, 8, all that, they will ask you about facts and how do you associate the relevant section to match this piece of evidence. Okay. Section 6, some people call it codify the common law of res gestae. Okay. So this is normally means what? If something that happened through the same transaction that could be admitted under section 6. Okay. If I give you one example, okay. This is a civil case, a running down matter. I drive a car and then hit a pedestrian. Okay, this is the traffic light. Okay, so the whole issue is about running down matter, motor vehicle accidents is a negligence, isn't it? Okay, if let's say there is a CCTV, not CCTV lah, a speed trap lah, that install at this what we call the traffic light, and so happen the pedestrian cross the road like that. I didn't see. I crossed, boom, and then this photo recorded by the uh, the the crossing the red line is called red gestate because it formed parts of the transaction. I hit this pedestrian and cross the road. You get me? Okay. So it shows the continuity of the action. Okay. Or I put one example to you one more time. Okay. If a criminal case, okay, I enter into a house and then I saw one lady there. So what I do is I threaten her with a knife. Okay. Then rob her. She gave me 500 ringgit. Well, on top of that, because she tried to run away, I stabbed her with a knife. Then after that, I run away. I run away. And this running away has been witnessed by the neighbor. So you can see, this is unbroken event. Okay, I enter the house, do something bad, then run away. Somebody saw. Okay, by right, the running away is not amounted to any crime, isn't it? It's not amounted to breaking in. It's not amounting to robbing. It's not about grievous causing hurt to that lady, but it could be admitted as Section 6, part of the continuity of my action. Okay, now you get me, It's not about the place and time. If you can establish the place and time, well and good. But the most important thing is it form part of the action or common purpose or design. The same purpose only lah. Because in the case of robbery, take for example, I cannot be telling the court say that actually I just want to enter the house. If I rob a person, it doesn't make sense, isn't it? If I don't want to escape from that house, how am I complete my act of robbing? Isn't it? Doesn't make sense. Okay, so this is part of the design of crime. You have to escape from that house. So slightly you think about what I say, and when you read the question, you have to put yourself into a scenario where you have to imagine a bit, okay? And section 7 got three things: occasion on which facts in issue happens, the cause of the relevant fact itself, and also the effect, okay? The effect of relevant fact or this facts in issue, okay? And it also said about the opportunity. This notes I'll give you lah. But those who don't want to read is okay because last minute better don't digest new information. You focus on those subjects that you are really mastered and score it well. And section 8 is about motive, preparation, and conduct. Okay, don't just write motive finish. Okay, cannot. If let's say I give you the example that insurance, okay, the buying insurance itself is not a motive. The insurance payout, I get money, so I get enrichment from the death of my wife. That is motive. So elaborate based on the facts. Okay. Another thing, preparation. Okay. I bought a knife on live. You cannot put just section 8. Okay, you have to elaborate. Since the disease was killed by Dr. Chi with a knife, and that knife was purchased by him through Shopee 2 days ago, this amount to the preparation of the whole crime itself. So complete answer. Okay, like this, motive, and you can what we call just mention one or two cases. Don't have to do too much. Okay. So absconding from the crime scene, conduct of the party. So you have to quote. Okay. Uh, okay. Section 9. I think section 9 is like a fallback section. Fallback section means uh, actually, this is a very broad section to be used. It could be used to explain a facts or relevant facts, introduce it. Okay, take for example, in in the case of incestuous rape, a stepfather, a stepfather rape stepdaughter. Okay, the seizure perkawinan between the stepfather plus the mother could be used under Section 9 to introduce their relationship, their stepfather and daughter relationship. Therefore, it could have incestuous, okay, not rape yet, but to introduce the relationship. Okay, it also can be used because, like I said, this is a very wide section. It could use to support an inference, rebut an inference, or even to establish identity. Take for example, if a neighbor hear his voice, heard the victim screaming, that victim is inside the house that at that material time, section 9 could be used. Okay, so this is how it works. Very broad section, very broad section. You try to check if, let's say, the facts given in the question you cannot fit into the ordinary like a section 6, 7, 8 out. Probably section 9 you can use. Okay. Hmm. Section 10 hardly used. 11, 14, 15, those are similar facts evidence lah. Similar facts evidence. Okay. And similar facts evidence, how to use how to use is a bit challenging lah. I would say similar facts evidence. Okay. Normally you admit similar facts evidence means to show modus operandi. Okay. If let's say I'm married for 3 times and this case is about I murder my current wife. Okay. She murder my current wife, and I have married for 3 times. But each and every single marriage, was ended by my wife dying, like before the age of 45 years old. Sure will die one. Okay. It could be normally, and how they die? Normally, they die inside a hotel with a knife stabbed into the heart. By right, if I'm charged with the murder of my current wife, all these issues in the past could not be raised because it is not related to the current facts itself. But in order to show modus operandi, each and every time I do like that, and this is the third time I'm doing it, repeated. So there's a striking similarity about the way of my wife, current wife, died with the previous two. So similar facts, evidence could be admitted. Okay, so this is how they play around, and it could be used to establish the state of mind lah. That means I have bad intention from the beginning. Okay, and form part of the similar occurrence 14, 15, and section 12 only for civil to determine the amount of damages. Okay. And normally how they use is that, let's say the amount loss, the loss one contract, and then subsequently have to find new replacement to top up money with receipt. All this is relevant under section 12 to assist the court to determine the amount of damages ought to be admitted. Okay. Hearsay. Now we come to hearsay. All right. Hearsay, first, when you how do you know when a thing is hearsay? Okay. How many types of hearsay is there? Anyone? Do you know how many form of hearsay is there? Okay, two. Very good. First, oral hearsay. Second, documentary hearsay. Okay. Okay. When you want to determine one issue from the question, whether it amount to hearsay or not, you must check whether it is a form of document or it is a witness. Okay, normally they'll give you a name lah. Okay, and in the event it is documentary hearsay, that means the maker, those who sign the document, those who handle the document, tak datang ke mahkamah. So this is deemed to be documentary hearsay because we cannot know for sure what is the real content, or if it's, I mean, the content, whether it is true or not, we cannot be sure because the maker is not coming to court. Whereby if it is a oral hearsay, means the saksi, the witness who hear or he witnessed by his own eyes about the incident did not come to court and give evidence. It is through third party. Itu menjadi one kabar angin. Okay, hearsay. And for you to establish hearsay, I mean, you should have know what is the reason why the court is not allowing hearsay now. Okay. For you to know what is hearsay, okay, this one is very important. It must be an out of court statement. Okay. First, first, very simple lah. First, maker tak ada, tak ada. So this is out of court statement. And such statement is actually being repeated in court or being tendered in court And the purpose to tender this piece of evidence is to prove the truth of the content. The truth of the content means untuk menunjukkan kebenaran ataupun kesahihan kandungan dia. Okay, let's say for example, I give you civil case lah. Okay, breach of contract. Okay, and I want to tender one agreement. And this is signed by my clerk. My clerk is signed. Okay. I'm acting on the capacity of Sendirian Berhad lah. My clerk is signing. Okay. The other party that signed is also not there, for example. Okay. So when this agreement is tendered like this by me, who is not the maker, I cannot say to the court that I know everything about the content of this agreement. Okay, now you follow me. The agreement itself will be rendered as documentary hearsay if I want to prove every single clause inside it for the purpose of the court to find out it's true. But whereas if let's say my clerk is giving the what we call this agreement and she's being called to testify, okay, I signed this, I have read it, I have personal knowledge about this document, then this is not hearsay. Okay, something like that. The truth, very important. And for the purpose of completion, to learn about hearsay, you must know the exception of hearsay. Exception of hearsay, important one is admission and confession. But admission and confession in criminal case now is subject to section 112 slash section 113 CPC. But in civil case, yes, still viable lah, this admission thing, okay? Admission of liability. And you have to look at section 32, primarily section 32 of Evidence Act, whether it falls inside or not, okay? And section 6, register, this is documentary evidence, the section 73A, and also computer generated document. So these are all hearsay exceptions. When this piece of evidence is able to fall under hearsay exception, then even though the maker is not coming to court to give evidence, still it is a form of admissible evidence. Okay. Section 90A, Section 90A, you have to, I think you need to know lah. Section 90A, normally Section 90A refer to digital form of evidence, digital evidence, whether it is WhatsApp lah, photograph, okay, CCTV, video, all that will be deemed as Section 90A. Computer generated document. And for you to admit under this provision, you have to further elaborate there must be a sigil. Okay, there must be a certificate signed by the maker. Okay, or the maker need to come to court. Okay, but since this is hearsay exception, the maker will not come to court lah. So you have to give a certificate in order to admit this piece of evidence, section 98. So res geste or section 6, I just told you, it form part of the same transaction. Okay, and it is also commonly known as the res gestae under the common law. But some book, of course, say that Section 6 will be broader than the common law res gestae provision. Okay. Hearsay rule is the strict rule because the court need to find out the truth, isn't it? And hearsay is macam kabar angin tau. The information has not been verified fully because the maker do not come to the court, so the maker could not be cross-examined by the defense counsel or by the opponent. So the credibility of this sort of evidence is very doubtful. For you to understand those exceptions, you must relate to the hearsay rule first, and then subsequently, all this hearsay exception is subject to very strict criteria. Because one is admitted under hearsay exception, the evidence itself will be recognized and being given weight. Okay, so that's why even if let's say this is a section 6 thing, the court will still need to evaluate whether this sort of evidence first, it is a very spontaneous type of reaction. It happens so quickly. Okay, it's a spontaneous event. Second, the mind of the maker that time, the mind of the maker who couldn't make it to the court now, lah, okay, at that time, has no time to think, Immediate response, something pop up from his mouth. Okay, said that, oh, I saw this, what we call the chi running away. It's him. So he has no time to fabricate the story, to made up or tell something that frame me up. Okay, so this is how the strict criteria being applied. Same thing only, so dying declaration also. Remember I told you the precondition section 104 must be satisfied. Okay, so what is it? The maker must die, no? And this is about the cause of his death. For example, the murder, I was being killed, I was being stabbed by a knife, I was stabbed by Dr. Chi, for example. So the cause must be this the cause, the death comes into the question, and it cannot be like, oh, I just go to Pasar Malam, something that is totally not related. Okay, and the the one more thing is that when the victim made this dying declaration, he may not be necessarily predict that he or she is about to die. There's no such requirement, but he think that he is in danger lah. He think he's in danger. Okay, this one is one, and second thing is this one. Section 32, sub-rule 1, sub-rule B. This one normally will come out in examination. So this one is about a statement of relevant facts made in ordinary course of business. Normally civil case lah. Okay. And normally in practice, we interchangeably use with section 73A. Okay. So this is also one hearsay exception. So the conditions, like I said to you, when you present your examination, you can say Ali must satisfy or discharge the precondition in order to use this section 32, sub-rule 1, sub-rule B. Namely, this out of court statement is a piece of relevant fact because the document is part of the transaction is very important to show the damages, etc. And second, you have to tell, the maker now cannot be found. Okay, now the maker is staying overseas, and various efforts had been spent to locate him but failed. And also, for example, the air ticket from London to Malaysia is very high, whereas the damage that we look at is small. So, not worthy to call the witness here. So, you must cite section 104. Okay, 104. And then subsequently, the next criteria is that sort of statement is ordinary course of business. Why I said so? Because this is part of the records needed for the operation of so and so business. Okay. And the maker is the one that made this statement. So he or she has personal knowledge. Okay. And this one, section 32(1)(b) is a single hearsay. Okay, not second-hand hearsay. It's a single-hand hearsay. Means the information only take, for example, this is the clerk that cannot come. I'm the director of the company. So it only pass one hand. One hand. Okay, I am the director lah. So it only pass one time. So single hearsay like that. If let's say this is the clerk and then it passed to the manager, then subsequently only pass to me, I'm deemed to be second-hand hearsay. Cannot. Okay? But I think they will not ask you so difficult lah. They will ask you this one. Okay. Where will be? Okay, section 32, sub-rule 1, sub-rule C. This one, I don't think is very common to be asked, so I'll skip that. And important one is section 32, 1, I and J. Okay, I and J. Where is I? Okay. So this is normally what they'll give is that a police officer retired and then he recorded something during the criminal investigation. There's a form of diary lah, diary that he have wrote in his when he was trying to investigate into the matter, but now he got sick or he died suddenly. And how we want to admit this diary since he's not longer available to testify in the court. So section 32, sub-rule 1, sub-rule I comes into place. And of course, you have to show this is a piece of relevant fact, number one, and maker tak boleh datang. Why tak boleh datang? You have to elaborate further because he's dead, he's retired, and various efforts have been spent to locate him. Okay, and the person that want to rely this hearsay exception rule must satisfy the precondition under section 104, must discharge this legal burden. Okay, subsequently, section 32(1)(j). Okay, section 32(1)(j) also you must satisfy. This is normally apa nama, when the police has this or the authority has discharged its official function. So this is section 32(1)(j). Okay. Also same, tak boleh datang, relevant fact, and the said officer must have done the discharge of his public duty. Okay, there's one dispute here whether section 32(1) I and J should be read separately or together. So these two cases, Cobra Taba Sedali said that it must be read together, and Siti Aisha, the latest one, said that by right should be separated. Okay, I will take one position. I will take Siti Aisha. Siti Aisha very famous case, Kim Jong Nam, the brother of the North Korea leaders, supreme leader, die in KLIA. Okay, so all this is and Section 73A. Section 73A, like I think I have talked to you, Section 73A used very often together with Section 32 sub 1 sub B. But this one is a broader one. It's a broader. It can be used in single or secondary hearsay. Even if the maker has no personal knowledge, you can also use this Section 73A. If you are not sure, if you are not sure whether this statement or the document it falls under Section 32 1B or Section 73A, the best guess is always Section 73A. Okay, because it's very broad, because it is a new amendment. Okay, new amendment. The purpose is memang to allow the tendering of civil documents lah. Okay, as a hearsay exception. Okay, case law, Alliance Bank against Yao Jok Hua. Just mention one or two. Enough. Okay, so the distinction, if you have time, you can read this one. I will share across the group lah. I'll share. And others hearsay exception, no need. Okay, we quickly go to character evidence. Character evidence, what is character? Character means reputation. Reputation means what people think about you, whether you are a nice guy, you are a good person or not. Okay, so this is reputation. And second thing is about disposition. Disposition means pembawaan, how you carry yourself is intrinsic. It is like you have inherent qualities. Okay, how's your habit? Okay, and this sort of character must be a form of general reputation and general disposition. That means to say it must it must have been over a time frame. Okay, a single act of doing charity does not necessarily carry means a person has good reputation, isn't it? But let's say when a person have done charity for the past 10 years without failing, generally the society will give him a good credit, a good reputation. Okay, so this is a general one. It's not just a single episode that can account for. Okay, what you need to know, character dalam bahasa Melayu means perwatakan ataupun watak lah. Watak. WATAK. General rule is that those character evidence is not the relevant facts and also not in dispute. Okay. The court is, for example, criminal cases. The court is only interested whether the person did wrong in this event or not. He's not interested about your past history. Same thing to do with the civil case. The court is only interested whether a doctor has been negligent in this surgery or not. He doesn't need to know this doctor is a datuk lah, won so many awards, have done 10,000 surgeries, good reputation from the patients, all that. No need. Okay, so this is normally not admissible. Okay, you follow me, eh? And character evidence is referring to section 52, 53, and 54 and 55. 55. Ayo, why I write very horribly. Okay. 52, 53, 54, 55. Out of this, 52 and 55 are applicable to civil case, whereas 53, 54 are exclusively for criminal case. It will ring a bell for you to use character evidence when you have a case and it is a civil defamation. I see most of the past year question that will only invite you to discuss character of a parties in civil case. Then you need to zoom in your 52, 55. How you elaborate? You say character is what? General reputation, general disposition of a person. Okay, in the eyes of the society lah, take for example, and it must stand over the time. So generally this is not admissible because this is not in dispute. But take for example, if it is a defamation case, can. Because why is that so? Why is that so? It will help the court to decide if, let's say, a person is having a bad character, a bad character, and then he sues someone for defamation. But you yourself has a very bad name in the community. How do you want to enjoy the benefits of being defamed? Okay. You cakap orang mengumpat kamu, tapi nama kamu sangat buruk. How? So this is relevant, you know. Okay. Or a person is enjoying good reputation and then some guy is having bad faith to defame him. Automatically, the court will award very high amount of damages to those who have good reputation. So this is for the sake of determine amount of damages. Very important. Okay. And 53 accused good character. The normally the character of the accused should not be disputed. Okay, because the court first thing do not want to have any bias or prejudice. Oh, you look at this Dr. Shi committed so many crimes in the past, so surely this time is him lah. No other people can do this bad thing because he had been repeating. This is his nature. His character is very bad. Okay. Normally, this is not admissible also. And if it is raised by the accuser, um, the prosecution, okay, or I put it very from the very beginning. Normally, the accused is being shielded. The prosecution cannot challenge the character of the accused unless a few exception. Okay, first exception, if we refer to section 54, 54, okay, 54, mana? 54. Sub rule 2. Okay, if you look at section 52, 54 sub rule 2. Okay, if the accused is committed the similar facts evidence, like just now the example that I've told you, to show modus operandi, the same killing wives in a hotel before age of 45 with knife. So unless it is for the purpose like this, but this one hardly being invoked by the prosecution, because you must understand in criminal cases, when the accused is being called to enter defense, normally prima facie has been made out. So prosecution already finished his case. So this will not be invoked. This section will not be invoked most of the time, and normally this is like academical purpose. Okay, like I've told you just now, if let's say this is criminal case, we have two stages, isn't it? Prosecution case or accused an accused case, and this is prima facie. During the prosecution's witness giving evidence, the accused counsel, the defense counsel lah, like us lah, okay, keep on casting imputation, said that the prosecution's witness are not trustworthy. They are full of crimes themselves. They have bribery. They cannot be they cannot be trusted. They are lying, and keep on saying that these weaknesses of the prosecution has bad character, and this thing is not done accidentally. This is a premeditation, is a pre-planting by the defense counsel to put down the credibility and trustworthiness of prosecution witness. Like this, the shield enjoyed by the accused is broken. The prosecution, if they ever know this accused has bad character, take for example a lot of past criminal records, etc., they can they can challenge the accused. You also lebih kurang sama lah, is a bad character person. Okay, so this is normally how the exception work. Okay, one case R against Butter was a in some other event is, for example, also through what we call meditation, premeditation, the defense counsel keep on triggering during cross-examination, keep on triggering the prosecution witness about how good character is the accused. Like for example, keep on asking the saksi. Take for example, I kill my wife again lah. Easy. The sister is coming to give evidence about my sour relationship, but I this defense counsel keep on asking the sister that, Dr. Chi is a lawyer, isn't it? He's very good. He got so many degree, isn't it? Yes or no? So he's also taking care of the children, isn't it? He teach CLP classes, isn't it? So all these are you try to project the accused as a good person. The prosecution can challenge it by tendering evidence to show the bad character. Okay, that means to say I'm not a good person, to strengthen their own case. Okay, so this is roughly how this character thing play lah. But use the right provision 52, 55 for apa nama for civil, 53, 54 for criminal. If it is ever raised lah, okay, if it is ever raised. And the 54 subrule 2, there's one special provision, subrule C, called accused. If let's say A and B, they have been charged for rape of C, raping C lah. Surely, during the accused stage, okay, during the accused stage, B will set that bad mouth lah, will bad mouth A. You see, A last time also was found to committed section 14 soka, touching an underage girl breast lah, and he was convicted. And this A, I know him for quite some time. He loved watching pornography. Push the blame to A like that, so that B can escape liability. In the event, let's say for example, the offense is the same, and B counsel keep on doing it, to make this A look very bad, or B himself did that during the examination in chief, then the prosecution can attack B's own character. Okay? And judicial notice. Okay, we need to be a bit quick. Judicial notice, as a matter of law here, all the facts which mentioned by the parties must be proved. At least you must back up with the certain piece of evidence, whether it's a real evidence, documentary evidence, whatever lah, or call some witness. But in the case that judicial notice is taken, in Bahasa Malaysia, it is called pengiktirafan kehakiman. Pengiktirafan kehakiman means Section 56, if the court take judicial notice, pengiktirafan kehakiman, this fact need not to be proved. That means to say you don't have to call witness, you don't have to give documents. Okay, I give you a typical example is that Malaysia is an Asian country, located near equator, and the weather is quite hot lah and hot. If you allege this fact in your pleading, in your statement of claim, Malaysia is very hot, therefore many people need aircon services, etc. You said Malaysia is a Asian near equator, hot. By right, since this sort of information is commonly known by the public, and it will make the court look a little bit stupid, for the person that assert this fact, for example, the plaintiff, to show the map inside the court, to ask a person that is good in geography to say that, oh, this is the equator, and to give the climate report from for the weather department or whatever, it will look stupid, isn't it? So to save this trouble, the court would be invited to take judicial notice regarding to all these three issues. If let's say the court agree, then the parties that assert this fact is exempted to tender proof in the court. Okay, no need. The court will recognize this as a fact. Okay. And Section 57 give all kind of lists that the court is allowed to take judicial notice regards to that. And the key case here is Pembangunan Mahamurni against Jururus Ladang Sendirian Berhad. Okay, and the test here is like this. The fact involved must be commonly known. Okay, in legal term, it is called sufficiently notorious. Okay, in a very layman term, everybody know it. Okay, everybody know it. Okay, so this is the test, and it becomes proper to assume its existence without proof. Okay, so the rationale behind is that to save the time of proving, and the judge is also quite clever. That is impliedly to say lah. Okay, otherwise it would be quite funny, isn't it, to prove every single fact that is so commonly known by everybody, but the court asks you to give evidence. He will look back on their side as well. Okay. Opinion evidence. Okay. Opinion evidence, don't be too fast, when you look at it, or a forensic doctor giving evidence, straight away you use section 45. Not like that. Okay. First thing first, you must tell The court is only interested in Section 5, correct? About the facts in issue and also relevant facts only. Opinion means what? What a person think. What you think is not very important to the court, except, except, uh, except such thinking will help the court in certain way to establish the diagnosis in medical negligence case. Okay, to find out the cause of death in the what we call the murder case. Okay, to ensure the quantity of the drugs in drug possession or drug trafficking case. Okay, unless these thing is relevant, I repeat again, the court will not accept opinion of a person. So this is general rule. Then subsequently, when you discuss about the opinion, you must also take a step to distinguish whether this information is a real fact or it is opinion. Okay, you read section apa nama section 3 of interpretation. Facts is something that how to say facts. There are two things. Whether this is a physically appreciated by a person or psychologically appreciated by a person. Physical means five sense lah. Okay, your five organs that you can appreciate the life. That is your ears, you hear. Your eyes, you see it. Your tongue, you feel. Okay, you smell with your nose. You touch with your hand. So this is five sense. This amount to physical facts. And psychologically, you are in fear, you are panic, you scared, you want to do it on purpose. So this is psychological fact. Can follow me, And opinion is what you think from what given to you. You infer. Okay. Take for example, I think this CLP is very tough exam and it requires a lot of efforts. So this is you're saying it based on something already, what you think. Okay. So case of Ku Hai Chang, okay, it is a case of drug trafficking actually, but now when the chemist is being invited to the court to give evidence, whether he is giving opinion or just appreciation of fact. In the sense that these chemists, why they say this is a fact is that they put in the drug packet, they pour the drug into this analyzer machine, and then the analyzer machine just give them the quantity of the drug. So the chemist did not go one step and think how much gram is this drug, isn't it? This is all the visual observation that this chemist has in the laboratory. So this is fucked up. Faham, Okay, I give you one more example. If let's say the chemist is comparing the fingerprint in his database and he think that this fingerprint on the knife is likely belonging to Dr. Chi because you see this itu apa the shape like this like this like this it is like matching my one, so he's giving his opinion in this manner. Okay, so must distinguish what is actually the purpose of that fellow coming, whether it's a factual witness or um he's giving opinion different okay. Then after that then you start telling section 45. Okay, section 45 don't tell in a very general manner, because section 45 give you five rooms or five categories of opinion. First is the subject matter related to foreign law that the court is not familiar with, or is an area of science or not, like medical lah. Medical, I think is quite this one, or is it pertaining to some sort of art? It is about the handwriting, signature, or fingerprint. Okay, so these are the rooms where your facts of the questions fit in. So you can say medical report itself helps the court to establish the identity of the culprit. Okay, or there is evidence of rape lah, because there's some tear over the vulvo-vagina area. Therefore, this is an area of science which is one of the allowed category under section 45. Like this, you elaborate your answer. So, and after that, you have to tell what you have to, if the question required you so lah. Okay, if the question asks you to do so, when you cite your section 45, you can give the outline of procedure, how to give an expert opinion. This one, if it is a civil case, order 40A, you must file an expert affidavit. So this is compulsory, affidavit pakai. And if it is a criminal case, okay, a report could be given under section 399 of CPC. Just now, this one, order 40A is the rules of court, rules of court. Okay, so this is how. And how you give is that you have to state what is your qualification. Is it by academic or by experience? You have give any evidence in the court before or not, whether the said evidence has been accepted, and what is your subject matter and the opinions. Most importantly, you must give what is the ground, what is the alasan. Kenapa kamu berfikir macam itu? Section 51 Evidence Act. So this constitute your complete answer. Okay, so this is opinion evidence. So handwriting and also signature. If you have time, it's not too late to read one case here. The Shembaga Valley against T.C. Hawk. Okay, Baga Valley against T. Seng Hawk or T.C. Hawk. I forgot. You have to check this case. Okay, this case is by Justice Merritt Peter. It teach you several ways where the handwriting of a person or signature of a person could be tendered in the court. The court could actually ask to sign on the spot. Sign. This is my signature, and it's different. Okay, or compare with the previous signature. Ask forensic expert from Jabatan Kimia, or ask the person who is familiarized with my signature. Okay, you can read about that. And role expert, 46 relevancy of facts, not so important. Non-expert opinion. Okay, so this is under section. Okay, handwriting itself. Handwriting, like I said, you read Shembaga Wali case. you can go for real expert that is coming from Jabatan Kimia Malaysia. That one is under Section 45. Otherwise, you can also call non-expert, those who know my signature. For example, my wife, my spouse, or my PA, personal assistant, who is every day seeing me writing. Okay, so this is Section 47. Okay, and the rest is not important, but anyone that give opinion in the court, okay, you must end your answer with Section 51. Okay, because this evidence must be supported with alasan. Kenapa kamu bercakap demikian? So, eventually, the court will look at this opinion itself plus the alasan to determine whether he want to accept this testimony or not. Okay? So grounds and yeah lah. And yeah, ultimate issue rules the judge is the one that decide not the expert. Okay, yeah.